Hello everybody. Welcome to our event. I am your host, Madalina Andrei, GMS, former Global Mobility Coordinator and currently Provider Relationship Manager with xpath.global. For those of you not yet familiar with xpath.global, we are the first SaaS-enabled marketplace digital ecosystem in the global mobility sector. To put it in plain English, we are the first e-commerce platform in global mobility arena that enables the direct relationship between local and regional experts and professionals, offering specialized services such as immigration, visa, taxation, social security, and destination services, and corporate clients in need of those services in all corners of the world. This is our 11th LinkedIn Live event from xpath.NEXUS series, a series which has its main goal to become a place where we can share best practices in our industry, to learn from one another, and most importantly, to grow together. This episode focuses on global telecommuting compliance. We'll be discussing mostly immigration matters and risks, and it's actually some sort of a sequel to a previous event we had, which targeted taxation and permanent establishment risks. Compliance in all its aspects and forms, from immigration to social security and tax, it became much more difficult when employees started to work remotely. And during the pandemic, of course, remote work has become actually quite the norm. However, a certain demand for remote work actually existed, of course, before the pandemic started. And I guess we expect it to continue even after the pandemic is over, whenever that might be. We can see that the popularity of remote working has now decreased when some of the restrictions were lifted, for example, or some of the job markets reopened, some of the industries returned to some level of normality. This means HR and global mobility professionals and experts are left to deal with the intricacies of immigration, labor law, payroll, and tax compliance risks. During this session, we will be privy to interesting and valuable insights from our fantastic expert panel here. And before giving the floor to my guests, I would like to thank all of the attendees for joining us and for watching the event. Please feel free to drop your comments and address your questions live. I'll try to address them if time allows it. And a very, very big thank you to our special guests. I would kindly ask my guests now to briefly introduce themselves, and I think we can do that alphabetically. We'll start with JC.
Hi everyone. I am Jyotirmay Chaturvedi, JC, and I've been part of the mobility world for almost the last 12 years, approximately. A chartered accountant by profession, I always had my inclination towards numbers, and therefore my obvious areas of interest and work lie in tax and comp and ven for mobile employees. My experience in mobility is divided between consulting and industry. I started my career in consulting with EY and then moved on to Genpact, and I've been here since then. During my years, I've worked on multiple projects that range from policy formulation to tax representation and designing business solutions. Extremely excited to be part of this session and to see what questions does Madalina has in store for me.
Thanks a lot, JC. Thanks a lot. Alastair?
Hello, everybody. My name is Alastair Mason, and I'm from Smithstone Walters. We're a UK immigration practice based in London, and I have been there for getting on for 10 years now. So I look after a range of corporate clients in the UK, from large multinationals in oil and gas to your local elementary schools and everybody in between. I help them navigate the UK immigration system. So we're looking at ICT visas, charity worker visas, and everything else as well. And that's me.
Excellent. Thanks a lot. John?
Hello, everybody. My name is John Heiser. I'm a managing partner at Maggio Qatar. We're a large boutique immigration law firm headquartered in Washington, D.C., with offices throughout the United States. And I've been doing this work for about 30 years now, and much like Alistair, represent a number of different types of companies of all sizes and in various types of industries, focusing basically on advising clients on case strategy, compliance, mergers and acquisitions, or the immigration consequences of those. I'm happy to be here as well to answer any questions you all might have.
Thanks a lot, John. Thank you, all of you. JC, I will start with you. I can imagine that in order for Genpact, but actually for any other company for that matter, to stay on top of the crisis, right? A lot of supervision and a lot of monitoring was done, right? With various borders being closed, various restrictions, immigration requirements changing overnight, quarantine, health requirements, local compliance, national compliance, and so on and so forth. How did you manage to connect all the dots and make sure you have the correct piece of information and details?
So Madalena, rather than saying connecting dots, I think what was more important was identifying those dots.
Exactly.
You're absolutely
Excellent.
right. You're absolutely
we need
right.
to know. We need to know what to connect. Right.
Yes. So you rightly pointed out your immigration scene was changing overnight. We had tax concessions getting announced, quarantine costs, quarantine requirements in different countries were different. And then we had a whole array of calls and mails flowing from employees narrating their situation. So honestly, at the beginning, it was slightly overwhelming, but then I'm glad that we, bounced back very quickly. At Genpact as a team, our mainstay was compliance. We just wanted to be at the right side of things. But at the same time, we had to ensure that we conveyed or we did our duty of care properly. We showed that empathy towards employees. So we had a multi-pronged kind of an approach, which covered largely tracking employees, talking to their business leaders, HR leaders to understand where employees are, tracking their immigration status to see if we are compliant, do we have a buffer till the time the visa expires, looking at the tax concessions. And if we had to move back the employees from the space they were in, we organized for central booking of tickets because every country had their air bubbles. So we organized for central booking of tickets. We issued CNB guidelines to support employees financially to settle and unsettle in different locations. And last but not the least, we understood every employee's personal situation as well. So, these were those small dots which formed part of a bigger whole and helped us tailor-make solutions for every employee. So I know it was not a cakewalk, but I'm glad we sailed.
Excellent, excellent. I'll continue in the same line of thought. With the pandemic here, I'm sure you would have observed possibly employees working remotely, right? What are the policy shifts that you have observed? I have here now like a series of questions, but they are all interrelated with each other. So what would be the policy shifts that you have observed? And if there were any specific challenges that your organization encountered with these remote work arrangements? If you do have a remote work policy, how do you keep track on your employees who work remotely and make sure both you as an organization, as an employer, and them are compliant? And all these questions are related to one of the questions we received from one of our attendees, Pratik Arlekar. Aside from the country-specific rules, what would be the key points a corporate should consider when devising and developing the remote working policies?
Perfect. So I think I'll take the challenges first, because any policy deviations or policy formulations we do, they're an outcome to cater to the challenges. So the challenges again would be twofold. Ensuring compliance. I think, like I earlier said, our mainstay has always been compliance. So ensuring compliance, employees are dislocated across the globe in different locations. And you have to be on the right side of things. So depending upon the country combination, the location, you have to design a structure or you have to get the employee back. And the second thing, I think, which is very important as a mobility professional is the duty of care. You have to have that employee centricity at the heart of all the solutions that you propose. So with both these things in mind, we did come up with remote work policy. We did also come up with some work from home policy. The remote work policy, as you called out, the important points that one should bear in mind. Honestly, no remote work policy can be all encompassing. Every country combination will have different kind of regulations
Rules.
which will be governed by the tax treaties that they have in place. They'll always be different. So you'll have to, as an organization, you'll have to understand the level of risk that you're willing to take. Do you really want to go all overboard? And, kind of, if I take a small example, a permanent establishment risk, you want to go all overboard and take the maximum threshold that any treaty prescribes, or maybe just stick to the lowest, right? So that's a call that every organization has to make. And then I think what is all more important is the change management. You have to educate the businesses that what the kind of risks that any organization will have to face if they are caught non-compliant in any region. And I'm sure no organization wants to be in that space. So I think these are the two considerations. And then obviously the final process nuances, I'm sure everyone knows of them. Putting the secondment structures in place, limiting the travels to a particular threshold, depending upon the visa category that the employees hold, what are the kind of activities they can undertake. They have finer process nuances, I'm sure everyone knows. But the key consideration would be to know that level of risk, which can cover all kind of country combinations, and then educating and change management driving that within the organization.
Excellent. Thank you. Thanks a lot. To get a bit into more specific details now, Alistair and John, I would skip other questions that are in my mind that will take me to this question, and I would ask you directly if remote work is allowed on a visitor status, because, well, I'm asking this because visitor's visa is usually the first thing that comes to mind. If it's not possible, what alternatives would employees have if they wish to work remotely from UK, respectively US?
Alistair, do you want to take that first, or would you like me to?
Yeah, the one word answer, Madalena, is no. You can't work, but I guess you want a bit more detail than that. So the UK is primarily concerned with your physical presence in the UK and the physical act of performing work. So it's not concerned with where you may be employed or where you're paid from. It's, are you physically in the UK performing work? And you can't do that on a visitor visa.
Any kind of work. Any kind of work.
There are some exceptions. So you can come in for meetings, you can come in for conferences. And for many people, that would be work. So some things are permitted that would be classified by as work by you and I, but they're not classified as work by the UK authorities. There are also some very specific activities, like you can install software on a computer, for example. That is considered a permitted activity under the visitor category. So there are these permitted activities that you can perform, but you can't come in and just do your routine job sitting at a desk, working day to day. There are also limitations insofar as you can't be paid out by a UK entity whilst you're here as a visitor, or again, some exceptions, but in general, you can't be paid. And of course, they look at the whole situation. So if you show up at the border and you say, I'm coming in for 8 weeks of meetings, it's a very strong likelihood that you'll be turned away and said, well, you're obviously going to be doing
it's very unlikely to have 8 weeks of meetings.
Exactly. And repetitive trips, frequency of trips, etc. It all adds to sort of being turned away at the border when you're trying to
possible refusals.
Exactly. So the short answer is no, you can't work on a visitor visa. The slightly longer answer is it's very grey, very complicated, and our advice is if you want guaranteed entry, don't take the risk. Get a work visa in place and enter on that instead.
Thanks, Alistair. John?
Yeah, and the US rules track exactly what Alistair just mentioned. It's about where the person is physically, right? The US system was designed to, at least with the visitor status, to promote business. Thousands of people enter the US every day as visitors, right? And they come for work purposes. But the visitor status, which is either ESTA or a B1, B2, is not generally a work authorized visa status. There are the same kinds of exceptions that Alistair mentioned. There's after sales, there's a very specific fact pattern that has to be in place to support that. But generally, you're not authorized to work, and the rule stems from, or the guidance I'm giving stems from a rule, the I-9 rules or regulations, which actually define what employment is, and that's defined in the law as providing or performing services for pay while you're in the U.S. It doesn't matter where the payroll source comes from, just like in the UK. It's all about where the person is physically. So we get this fact pattern a lot with my clients. They ask, okay, or I discover, or the HR department or the legal department discovers that the person's here in the US, they're undergoing training, let's say, a specific type of training that's permitted as a visitor. But then at night, they go to their hotel rooms and then they start working doing their normal jobs that they would do, outside the US, and that's not permitted. There's no specific guidance from the government on this. Again, the system is intended to promote flexibility in business. So what you're left with is understanding the rules, and then these gray areas that Alistair mentioned, and trying to fill them in with some guidance. And so what we generally recommend is, okay, you can check your email, right? You can check in with your colleagues or your manager, but you're crossing the line if you start doing your normal job, right, that you typically do overseas while you're here in the United States.
Thanks, John. I'll get back to Alistair, and the next question would be, Alistair, it sounds as far as I know, at least, it's a bit like almost impossible to work in UK without an entity in the UK acting as your sponsor, right? Well, is this true? And what happens in case, I know it's true, but what happens if the respective company, if a company does not apply for sponsorship? Meaning, okay, you can't work based on a visitor visa, but the employer which would like to hire you does not want to act as your sponsor either. Is there something like that? Do cases like this exist?
Yeah, they do a lot, especially at the start of a company that may be based overseas and is first starting up in the UK. They won't have the structure in place, so they might want to hire their first overseas national without having an entity in the UK. And unless that overseas national has some other route to the UK, like their ancestral links, or there's a category known as global talent for particularly talented individuals, then it's very difficult. And what we see quite a lot is agencies that offer to sponsor you. So an agency would act as a sponsor, they would employ you, and they would then hire you out to your employer as well, or whoever defines your role. But the UK authorities are firmly against this, and they really crack down on these agencies. There needs to be, between your sponsor, who's sponsoring your visa, and the entity that you're performing work for, there needs to be a connection there. If there isn't, then your sponsor can't.
Like some sort of an agreement or a contract, or
exactly. So the most common sort of agreement we would see is with the likes of Tech Mahindra or Tata, etc. They would sponsor people in the UK, and they would then second them to O2, Telefonica, or whoever it may be to perform their role there. And that's permitted. And that's permitted. That's fine. What the UK don't want to see is agency B sponsoring somebody and then saying to another company, "We've sponsored this person. Here you go. You define their role." There needs to be a definition of role, control over salary, etc., etc. And that's why agencies and the UK sponsor system don't really lie together. It's not possible to seek sponsorship from somebody other than your employer.
So I guess that answers the question, what happens if the company doesn't apply for sponsorship?
Yeah, so if you don't apply for sponsorship, someone will approach you and say, "I can sponsor your worker," but you should firmly turn them down and say, "No, it's got to be us that gets the sponsor license." Super.
You mentioned Tech Mahindra, and I think Pratik heard you. because we have a question from Pratik Arlekar, the head of mobility in Tech Mahindra. Do we have to pay UK salary equivalent for ICT migrant workers who move back to offshore, home country, for a few months to support the project from offshore and then will return to the UK?
No. So you simply, we have a government portal for sponsorship. It's called the Sponsor Management System. When a person leaves the UK, their salary no longer needs to meet the ICT threshold, and you update that portal. Then when they return to the UK, you update it again and just keep it up to date. And that by that means you can lower their salary when they leave the UK or change their salary.
Excellent. Thanks a lot, Alastair. We'll go across the pond to John. John, to bring employees to US or to hire foreign personnel, US employers, they go to great length, right? For the person in question to be considered for an employment-based visa, the employer needs to receive several approvals from various, I'm not sure if I say it right, but labor departments, I guess, and then file a special petition. And apparently there is a lot of extra effort involved in doing that. And here I would have two questions, actually. How eager are the US employers in getting started this procedure? And if companies, if they're not eager, if they don't want to get involved, what options are left for the individuals? And how do companies expect to attract talents and skills without actually making this effort?
Okay, great question. In particular, currently, I would say just based on the questions I'm receiving from clients, we have thousands of clients located all over the world, and the U.S. companies are as we say, dying for they have a number of open positions. The labor market here is really tight, meaning that there's a high demand for talent right now. And my firm is extremely busy these days trying to come up with solutions for individuals, trying to hire basically any types of open positions. I just received an email this morning from a healthcare company because they have a severe shortage of nurses and any other types of staff in hospitals and nursing homes and so forth. Unfortunately, the U.S. visa system is not geared towards hiring foreigners working in unskilled positions like unskilled labor. It's really meant for bringing over highly talented foreign national workers working in professional positions, or for intra-company transferees who are professionals, managers, executives, and so forth. But right now, are they eager? I would say extraordinarily eager. And I'm seeing that, again, every day. And we have to, unfortunately, provide the answer sometimes that, no, you just can't do that, right? Really, we have very few visas that are available for unskilled labor, and those are usually snatched up very quickly. I'm thinking of the H-2B visa. But yeah, our system is extremely complex in the US. Several different government agencies are involved with their own rules that sometimes conflict with one another. And essentially, that's why I have a job, right? I mean, it's a really complex system. And but yeah, employers will go to great lengths to hire foreign nationals in particular. And if not, what can you do? It's much like what Alistair mentioned is in the UK. It's really a sponsored based system that we have. We do have a few exceptions. For example, if you're a highly talented individual expert in your field, and you can qualify for an O1, O is an Oscar, then you can secure an agent, right, to sponsor you. You don't need an offer of employment from a U.S. company. But beyond, and then there are a couple of permanent resident categories or green card categories where self-sponsorship is possible. The employment-based first, EB-11, extraordinary ability, it's much like the O1, right? And the national interest waiver can be self-sponsored. Okay.
Excellent, excellent. The next question, still related to this idea. Would there be any specific questions and actions? Sorry, any specific actions the employers need to take in case employment conditions change, such as employees, for example, working remotely or from home, right? Again, I know H-1B visas, visa holders can work remotely as long as their location, as law mentions, is within normal commuting distance, right? How do you define this normal? And what happens if an employee wants or has to work from a different state, for example?
Okay, so this is specific to H-1Bs, right? Because other visa types that we have offer flexibility, and this rule is simply not applicable, right? So for an H-1B worker, you have to understand kind of the area of intended employment, right? That is defined in the law as you're either within normal commuting distance of your home, right, or the work site that's been approved, or you're within what's called the Metropolitan Statistical Area, or MSA. And an MSA, you can find guidance online from the Department of Labor of what a particular MSA might be. But defining within normal commuting distance has gotten to be pretty tricky, right? Because you know, people are oftentimes commuting great distances for work, and so you have to make a judgment call in conjunction with your counsel, understand the risks. What you're really dealing with, you know, why maybe perhaps filing an H-1B amendment to cover the new work site might be a good idea. Currently, the government isn't as strict on off-site work as it was, I should say, several years ago, where you had to come up with a bunch of different documentation and evidence to prove that direct employer relationship exists, right? And so consulting companies oftentimes had a really difficult time securing H-1B approvals. Now, one of the, I'm going to get in the weeds just a little bit, right? Because one of the issues I'm seeing with remote work is, you know, the home work site, and how do we cover that? So when COVID started, the Department of Labor gave some guidance that's, you know, that basically reinforced the rule that is on the books, and that is that if you're within the same area of intended employment and a new work site comes into play after the approval, or actually after the filing of the labor condition application used in the first H-1B. So it's something that's unanticipated, is what the rule says. You know, this just happened, it popped up, just like COVID did, right? You're approved to work at the office, COVID happened, I want to work from home. Okay, then you have to post notices at the home, which sounds silly because there may not be anyone there to see it, right?
Exactly.
Besides your cat or your dog. And we had some crazy questions from people, you know, trying to post the notices on their garage doors on the outside of the home. You know, do I post it in my bathroom, my refrigerator? You know, it's bizarre. But if you're going to work outside of the MSA or the area of intended employment, then you may be eligible for something called a short-term placement exception, where nothing has to be filed or posted, but there are very strict rules in place about eligibility for that benefit. And it's a very temporary thing, right? Otherwise, you're
limited
required
in time. Yeah.
Right. You're limited in time. And again, I can get into it, but I don't want to, you know, overdo the discussion. But you have to file an H-1B amendment to cover that area outside of the area of intended employment.
Super. Thanks a lot, John.
Yeah.
We already see we have well, compliance risks are present in the immigration sector, perhaps not as much as in tax or social security. JC, in your opinion, what would you say the remote work had? Would you say the remote work had an impact on tax regimes, for example? What are the kind of changes and impacts that you've seen and you anticipate for the future?
So honestly, yes, the tax regimes did change, but those changes are very minor in terms of extending the payment deadlines, the tax filing deadlines, and pretty much they came as a response to the pandemic. The only big change was OECD announcing some guidelines, but then even they left it to the countries to design their own regulations in accordance with that, and policies in accordance with that, and it wasn't even mandatory. So you could or you could not. Like India, for sure, I know they didn't do it. A lot of countries didn't otherwise do it. So any changes that we saw then were primarily in response to the pandemic. But I think once we start normalizing and we're talking about remote work, that remote work starts picking up, I think some changes that I personally anticipate will be in terms of redefining of some of the clauses in the tax treaties. Something like a new definition for permanent establishment that will encompass something more to cover the remote work kind of a situation, because the ultimate beneficiary is already obviously lying somewhere else. Similarly, something to share the taxes. When I say taxes, in the personal taxes, something to share those taxes. Then or some other changes could be totalization agreements, the social security agreements that we have. The extent of social security agreements is really not as wide as treaties. So I think I see them growing in number. And again, some clauses to, so growing in number, and then something to cover again the remote work. And I think one important factor would be the buzzword around gig workers or digital nomads. I think there'll be more coverage, there'll be provisions and regulations to bring greater governance around that. So these are the changes I anticipate, and I think we as mobility professionals will have a lot of learning to do in times to come.
Definitely. Thanks a lot, JC. And I will take one of your key recommendations and impacts that you foresee, and go to Alistair and John and ask them if UK and US are considering having in place one of the recently digital nomad remote worker visa that some countries already implemented or are thinking to implement.
I can go first quickly, Alistair. The answer is really
no. The answer is no.
Right, it's unrealistic. Getting any kind of changes to our laws these days for immigration is just extraordinarily difficult. So no, I don't foresee it, at least not anytime soon.
I echo John for the UK. They're talking about tweaking the skilled worker visa to make it more flexible, but the UK is very much focused on the compliance being on the side of the sponsor, and I can't see that changing. We've just
anytime soon.
No, not in the immediate future for sure.
Excellent. JC, I'm getting back to you. How do you see the current mobility trends in your personal perspective, given the rise of remote work scenario? Traditional assignment structures, will they be kept? STAs, LTAs? What trends do you see emerging given the circumstances in the past couple of months? Do you believe the pandemic changed the paradigm?
Yes, it certainly did. How I see it, that long-term assignments or the traditional kind of assignments, I don't think that they'll stay for long. We'll obviously see a dip there. Telecommuting, we're talking about it, remote work, it's here to stay. I think it will just grow over time. However, the third thing that we say, the gig workers, that is something I feel that might just pick up, but not to the extent that we see the buzz around it. And that's obviously because of the reasons around the compliance challenges that it brings along. And another third-party vendor getting integrated into the entire structure. So I don't see that gig workers will pick up that much as remote working.
Super. One more question. The remote work might be well, we know it's might be beneficial for both employees and employers. Some companies already advertise these remote working scenarios as part of their benefits, right, packages. Other companies that might be reluctant to go remotely or allow their employees to work from anywhere or from home or whatever might miss on the talents and skills out there. Would you say that this rise in remote work and the popularity it has will have an impact on employees' hiring and job application process? And if your organization adapted or modified or changed anything in your internal policy to suit this new reality?
I'll first take the latter part. Our organization has always been known for its flexibility. So we really didn't have to change much internally, but yes, we did come out with certain policy guidelines around work from home and remote working. And then going back to the application process, yes, I do see that it will impact the application process because nowadays you just log into LinkedIn or you go to any job site. There are people, you will hear accounts where people are interested, where you at least giving them a hybrid kind of a model. They don't want to get back to the old normal of working from office completely. But I think how organizations adapted, that will be completely an organization specific decision because at least here we see a couple of big names in industry going back to office process like 100%.
Yeah, super. Thanks a lot, JC. Alastair, given the new realities, working from home, remote work, working from anywhere, you name it, have you identified possible new trends in companies modifying their internal policies in hiring new employees worldwide without an on-site presence? Thinking about your clients, perhaps.
No, we haven't.
No,
We've
not
seen,
really.
no, we haven't. The big change for us really has been the introduction of continental Europe to the visa scheme. So people who were telecommuting from Europe, now you can't do that unless you apply for a work visa.
Unfortunately.
And work visas in the UK cost up to £10,000. So that's where we've seen a big change in the system. So it's kind of the two things coming together, Brexit and COVID remote working. COVID remote working saw a huge number of people leave the UK, something like over 500,000 leaving London alone to go return home to Europe. And at the same time, Brexit hit. Well, those people are now working remotely from Europe, but their employers want them to come into the UK from time to time to work, whether it's on a weekly basis, monthly basis, or more infrequently than that. But those individuals now need to have a work visa potentially to do that. And that's where we're seeing a big change.
They won't be able to do that on a visitor's visa.
Well, potentially, but then we go back to what can you do? So if they're going to come in and I don't know, design games for a computer games company, then they can't perform their routine role. So it was the perfect storm really at the end of last year in terms of those two things hitting at once and people becoming remote workers without ever actually wanting to be permanent remote workers, or their employers not wanting them to be anyway. Yeah.
Thanks, Alastair. Across the pond again with John. What would be, John, the current status of the national interest exception waiver process, which is the additional COVID travel restriction created by the Trump administration?
Yeah. Okay. So Monday, right, the White House announced that beginning November 1, the travel ban would be lifted, right? Unfortunately, and as of today, we still don't have any specific guidance. For example, would that include all 33 countries that are subject to the travel ban at this point? More than likely, it's going to be Europe. I mean, that's been the focus. There's been a lot of pressure from the EU and the UK on the Biden administration to lift the travel ban for folks who are there in Europe, right, coming to the US. Beyond that, it's going to be interesting to see if they'll apply they'll lift the ban for folks in India, China, right, South Africa, Brazil, where COVID is still a very big problem. So that's the current state, is we don't know quite yet. And what I think what folks are assuming is that then the U.S. consulates will just reopen for normal business, and I don't think so. I mean, we're starting to see, most U.S. consulates are closed for normal visa operations around the world. We're starting to see some reopen for normal operations, others on a limited basis. So my sense is that although the NIE waiver requirement will be lifted for most, if not all, of these countries, travelers are still going to find it hard to secure visa appointments and may have to go through the emergency appointment request path, which can be difficult, right, and expensive.
We have thank you very much, John. We have a question from Stefan Hoffman, Global Alliances at Deal. Have any of you had success getting EOR, employer of record subsidiaries, to sponsor work visas? Who wants to take that?
I can say yes. So in the UK, one entity can hold a license, and multiple entities can piggyback off the back of it. Some companies will have individual licenses for each entity, so they split up the risk and mitigate any compliance issues that one entity might have. But then again, other entities that we work with, they will have 400 plus UK entities under a single license. So if you have a often distant to HR known entity in the UK that already has a license, you need not get another entity another license when you set up a new entity. You can just piggyback on the back of the existing organization.
Super. John?
I was just going to say, so our system is different than the UK system. So for intra-company transferees, you're either dealing with companies that are eligible for and have what's called a blanket L certification, or you have to petition USCIS. And there we go back to your prior comment, Madalena, about how complex our system is and all these layers. So with a blanket, it's relatively simple. If the companies are legal and the legal entities are listed on the blanket, then the petition and application are made all at once for the visa at a U.S. consulate in the home country. The trick now, of course, is the COVID restrictions, the consulates being open or closed. But have we seen success? Yes, it can be done. We're very busy. Employers just need to be prepared for a no for plan A, and then jump to plan B, and then so forth and so on, right?
Thanks a lot for that. John, we have a question from the audience as well. There are situations where employees' visas were maxing out and they couldn't travel outside. What were some of the solutions that you have observed your clients implementing, or actually you suggested to stay compliant?
Right. So the government was very strict. They didn't offer many kind of solutions here, or emergency options due to COVID. So the individuals, foreign nationals, were left to try to figure out a path on their own. Many filed changes of status applications to a B1, B2 visitor. The folks who were here on ESTA had a harder time, because on ESTA you're supposed to leave. There's no option to stay, but the government did offer some temporary solutions there. And if you were here on a work authorized visa, then what we were trying to do is develop a strategy to see if we could extend that person's status. Could we, maybe change their status to another visa type? And I would say, by and large, knock on wood, our clients are pretty successful in being able to keep folks who are here and then working, right? And then kind of suddenly stranded as a result of COVID, either because they couldn't travel back home, right? Or, because, ordinarily they would have to renew their visa and then they would come back. But we've developed strategies on filing the extensions, maybe waiting till the last minute to file. Certain visa types offer work authorization in the US automatically for up to 8 months. Based on a pending case. So we would we would basically take advantage of the slowness of the US immigration adjudication process to keep people here to wait out COVID, so they can maybe go back and apply back home where they have more chances of success, for example. And here I'm referencing, what I'm talking about is an L1, right? If a company has a blanket, typically they'd want to use that blanket again to renew the visa status, to extend that person. But during COVID, right, the consulate shut down, there was the NIE, they couldn't go back home. So we would wait to file until the 11th hour, get the 240-day work authorization extension, and then see if they can then go back home and try a blanket. Because USCIS is much tougher on L1s than the State Department is, which runs our consulates overseas. Okay. So it's been a crazy time.
Crazy period. Thank you. Alastair, what would be the key immigration issues and problems that your clients are usually facing?
At the moment, there's a lot of people who are still stuck overseas, or they're choosing to be overseas. That's a big issue for UK entities who are sponsoring them, because after you've spent 5 years in the UK on a skilled worker visa, our main category of sponsorship, you qualify for your permanent residence, but there are limitations on how long you can spend outside the UK each year. And obviously, if you've got an employee that's spent a year working from their home country, then when it comes to 5 years down the line, they're going to have such a large absence in their history that they won't qualify for their permanent status. And as an employer, you're going to have a block of potentially 100 individuals that can't get their permanent status. You will have to extend their visas and incur the costs of that. So that's one big fight that our clients are having with their employees. Employees are saying, well, you can extend my visa in 3 years' time. And employers are saying, well, we don't know. It might be that it might cost the price of a small home by that point. So there's this ongoing argument. And we've actually seen companies offer bonuses to individuals to return to the UK to avoid this. Because it's cheaper to pay somebody a bonus than it is to pay the UK government their visa fees. So that's a huge issue that we've seen, and just the fees in general. So as I said, to sponsor a single individual for up to 5 years, the maximum you can sponsor in the UK in a single application, you're looking at ballpark figure of £10,000. If you have a family of 4, that goes up to closer to £25,000 by the time you've added in all the extras. Yeah. So our system was recently relaxed, and you can now sponsor a greater number of roles. You can sponsor down to high school level qualified personnel, but you're then going to have to spend up to £25,000 of fees. So again, employers, it's not so much the technical aspects of applying for a visa that we're working with our clients on. It's the cost and the forward planning.
The financial.
Yeah. The financial aspect, yeah. So those are the big issues for us.
Thank you very much. Another question for both Alastair and John. What would be, in your opinion, the main risks in case of immigration non-compliance in UK and US? And I'm thinking, are these risks covering only the employees or only the employers, the entities? Could you just give us a few examples?
Sure, I'll give you several here that come to mind. So the risk is to both the individual and the employer. On the employer side, depending on the visa type that the status that you're violating, what the compliance issue is, you could be barred from sponsoring foreign nationals for a number of years. And that's for every kind of visa classification, including permanent residence or green cards. Yeah, then you have the I-9 violations, where there are civil and potentially criminal penalties. Criminal comes into play when there's a pattern and practice of knowingly violating the rules. There's also criminal penalties on the visa sponsorship side for perjury, because you're signing off, the individual signing off on behalf of the company, maybe it's signing on penalty of perjury, basically. So if there's fraud or willful material misrepresentations that are willful, then potential criminal penalties come into play. For the individual, you could be somehow impacting their ability to get a future visa benefit or permanent residence in the United States. And some of these penalties are, in many cases, they're rather severe. So it could be, for example, a permanent bar, 10-year bar. I mean, there are a number of these bars that we have in our laws. There are waivers for some, but not for all.
Sounds pretty menacing. Really,
it is. Yeah.
Alastair, what about UK?
It's a similar deal from the UK, really.
Okay.
And interestingly, when you apply for a UK visa, it asks questions about your other visa statuses around the world. So if you have faced bars in the US, the UK are going to ask you about it, and they're not going to be so willing to hand you a visa if you're barred for visa violations elsewhere. So it has a knock-on effect. Other things in the UK, people will be Googling this now, but they publish the businesses that have been fined every quarter. So if you've been fined for illegal employment, you're fined up to £20,000 per individual. But possibly, I would say for many companies, it's in the public realm. So you can go and find out who's been fined every quarter in the UK.
So I think we're talking also about reputational risks, right?
Exactly, reputational risk. That's not to say as well that you could lose your license, like John was mentioning, your right to sponsor individuals, and any individuals that you're currently sponsoring, of which some of the bigger companies in the UK are sponsoring 10,000 upwards. They can lose all their visas as well. So you'd have a knock-on impact. Your employees' visas and the visas of all their family as well. So the impact is pretty severe. From an individual perspective, similar to the US, it's bans from the UK. So up to 10-year ban from the UK if you're found to have deceived the UK authorities. Deception could be something as simple as you claiming that you're coming to be a visitor in the UK and they don't believe you and they have evidence to prove otherwise that you're actually coming to work. That would be deception. So the repercussions are pretty severe.
For all actors involved, actually. Yeah,
absolutely.
Thanks a lot. To wrap our session, I would have a question that would be addressed to all three of you, and I would start with JC. The same question. What would be the two key compliance considerations one should bear in mind for telecommuting in your perspective? JC?
I think immigration, John and Alastair will cover, so I'll not mention that. I'll keep it to tax and social security. And
I knew it, JC.
And one thing we seem to be missing is data privacy. I think with the remote working, so much of information is sitting in different nooks of the world, nooks and corners of the world, that the data privacy becomes one of the biggest concerns. And with a lot of these client MSAs and SOWs covering this aspect, I think it's all the more imperative for organizations to start looking at it. So yes, data privacy is one of the biggest things, and then tax and social security we've spoken about a lot. It's important to look at the country combinations, see where your employees are sitting, and accordingly design structures. Or if you have to understand what compliances you need to undertake. So it's very important you understand the country combination and the length that the employee stayed.
Excellent. Yeah. Thanks a lot. John?
Okay, so I think the first thing that comes to mind is a question that we get. This could be a good follow-up to the prior question you posed to us, which is how do they know? How do the authorities, so what if there are these risks? How are they going to find out, right? There are a lot of mechanisms in place, enforcement mechanisms to catch people and companies these days. The example I can give, harkening back to the very first question about remote work, or people entering as visitors and then working remotely here. We actually I had a client that was investigated by the government for that very reason, because the employee complained. The employee filed a complaint with the Department of Labor, and because he wanted to be compensated for that extra time. He was, in his mind, working while attending these training sessions. Then he goes back to the hotel, works another 6 hours, so a complaint was filed. There are also site visits that the government makes after a case has been approved, after a petition has been approved. And so they're watching. More and more the systems are tied together, even with other countries. Alistair mentioned, the UK looking at other countries, and we do the same. So there's a lot of enforcement out there right now. And the other one is, again, just quickly what Alistair mentioned before, which is important in the US, and that's reputation. If you're a bad actor in the eyes of the government, you're going to have a very hard time, with your visa sponsorships in the future.
Thanks, John. Alastair?
My 2 points would be firstly, simple one, but have a gatekeeper to the UK. It's so often that you see clients that have individuals that just decide themselves that they're going to travel to the UK for a month or 6 weeks. And if that travel has to come through be approved by somebody. I know there's travel desks, etc., but if it's approved by somebody that has an immigration perspective on it, then you'll whittle out these business trips that aren't really business trips. They're people working.
They will not be allowed.
Exactly. A gatekeeper.
If you have an immigration person, they will not be allowed.
Exactly. A gatekeeper to this that can stop. The famous line is, well, Steve does it, so why can't I? That's always comes up, right?
Yeah.
So that's my biggest thing, is have someone that is a gatekeeper to everything. And when somebody's here in the UK as well, if there are any changes to their employment, we need to report it to the UK authorities. Again, if there is a gatekeeper there that every change goes through that person or through that team, then these things will get picked up and you'll remain compliant. But when it's a free-for-all, it's impossible to manage. So that would be my number one. Number two is factoring in immigration as early as possible. We're sort of fortunate in the UK insofar as you can get a visa pretty quickly. In New York, you can get your UK work visa within 48 hours even. So very quick. But factoring in the costs of it, and if you've already agreed to bring somebody to the UK and then you realize they need to sit an English language test, they need to sit a TB test, it's sort of the age-old story of thinking about it before it's an issue. And that's all the more important now for Europe, because previously people would just step on Eurostar and get off the other end in London and work. And now they're having to factor in that extra week, 2-3 weeks to get their visa. So those are my two points around compliance, remote working, and sort of the visitor.
Great. I think I have a lag, and I see the questions from the attendees a bit later than they should. Then I should see them. One more question from Pratik. Given the pandemic uncertainties, do you reckon the visitor visa's validity duration should be revisited by all countries? And he says US gives a good 10-year B1, UK has 6 months, but one has to pay hefty fees for 5 years, 10 years, valid visitor visa. ESTA validity should be increased to 5 years. I guess, please.
Go ahead, sorry. So the validity of a visa stamp, that doesn't govern your stay in the US. That just allows you to visit the US during the duration
period,
right? And our system allows for the officer admitting before a national to determine the length of stay. And what we're seeing now is, rather than just giving them the blanket 6-month duration, which they would do very, very often, we're seeing a more thoughtful approach, more questions, and the limitation on the I-94 record, which does govern your stay in the US, right, being applied. Right, so you're not being given the blanket 6 months anymore. It's more tailored towards the duration of the visit. Right.
Super. Thanks a lot. I think that wraps this session. It's been great. I'm sure our audience found it really interesting. Thanks a lot for taking the time to join us. Thank you very much to our guests for all the great insights they have shared with us. Thank you, attendees, all the attendees, for joining us and for watching our event. In case you need further expert advice or have any questions, please feel free to reach out to my guests directly. I'm sure they'll be happy to help. Meanwhile, please follow our xpath.global pages on LinkedIn and YouTube to get updates on our new live events on hot topics in the global mobility sector. Thank you all again very, very much, and see you in 2 weeks' time. Bye-bye.